My name is Reghan Greer. I'm the Change and Communications Manager for Legislative Reforms here at the QBCC. Before we kick off today, I would like to take a moment to acknowledge the traditional custodians of the land on which we meet today and pay my respects to elders past, present and emerging. I'd like to extend a nice warm welcome to all of you for joining our Plumbing and Drainage Reforms webinar. I have here with me Grant Wilkinson, who is QBCC's Principal Plumbing Investigator, and together we will be providing you with an update on the new plumbing laws, how they impact you and our industry. Now, before we begin, I'll step through a few basics to help you get the best out of the webinar. Although you can't see us and we can't see you, you can still interact with us via the question field to the right-hand side of the screen. At any time during the presentation, feel free to pop your question in there. We'll either answer them as we go or at the end of the session. Now, there's a large number of you that have logged in, so don't stress too much if we don't get to your specific question. I'll try and go through the questions and get a sort of a similar theme for the questions and answers. And what I will do is after the session, if there's any questions that we haven't answered, I'll actually collate them all, get you a written response, and I will send them all out to you in the next couple of days. So also, if you missed something today or you have a mate that might be keen to hear the presentation, we'll be making all elements of this webinar, including a recording, the supporting PowerPoint that you can see on the screen, and the handout that you can see in the chat there, will all be available on the QBCC website from the 1st of August. Now, just to help with today, we're going to be making references to documents, links or to the website. So there is in the chat, which is on the right-hand side of the screen, a fact sheet, and it's called Plumbing and Drainage Changes. I've given an example there on the screen, and you're more than welcome to open that up. You can interact with any of those links that are in blue on that fact sheet in real time. It also might be a good idea to save a copy of this to your desktop or your tablet, whatever you're using, so that you can refer back to it in future. Now, it's kind of in order as we're going to be speaking. So let me give you a bit of an overview of the flow of this webinar. So I'm going to carry on talking and take you through an overview of the changes and the impacts to the industry. So it's just a high-level overview of the changes. I'll pass over to Grant and he'll go through the notifiable work changes and what you need to know, the approved audit program, in the new offences and the changes to the existing offences that you need to be aware of. And he'll also go through safety incident reporting, which may be new to some of you. And then we'll go through and we're going to answer some questions. We did this webinar on Tuesday night and we had a huge amount of questions about notifiable work. So a bit different, that what we're going to do tonight is a little bit different. After Grant has finished the discussion on notifiable work, we're actually going to start looking at some of the questions that you have asked, and we're going to provide you with some answers. So when you ask the question, it comes through, we can see it here. So all of you can't see it until we answer it and send it out to everybody. So I'm now going to go through the summary of changes at a high level. So we understand that the plumbing and drainage industry is integral to maintaining the health and safety of our communities. So under the Queensland Building Plan, the state government made a commitment to our industry to establish laws that are clear, consistent and provide benefits to the industry, licensees and homeowners. So these new reforms that were introduced on the 1st of July give the QBCC much stronger powers to tackle some of those key concerns and pain points that industry have highlighted over the years. One of the first pain points was to do with dual licensing. So earlier this year, we saw the Plumbing and Drainage Occupational Fee Amendment regulation come in, and that provided them some much needed clarity on the subject of dual plumbing and drainage licenses. So that is if you hold your occupational license and also a QBCC contractor nominee supervisor or site supervisor license. As a QBCC contractor licensee, you must ensure that you hold the appropriate occupational license. So if you hold an associated contractor QBCC license, then no fee will be payable for application, renewal, or restoration of your occupational license. Now, if you only hold that occupational license, fees do still apply. And I will point out that under that piece of legislation that came in, there was only an additional year's grace to make sure that your occupational license is up to speed. So please contact us if you are unsure about your occupational license requirements if you hold a QBCC contractor license. We've also had from the 1st of July a register. Now, this is a plumbing and drainage licensee register. It was made publicly available on the QBCC website. There is a link to the register provided in that fact sheet. It's the very first link. Now, that register displays publicly details about plumbers and drainers with an occupational license as prescribed under the Plumbing and Drainage Act. The details that are in there is licensee name, your license number, any conditions and endorsements that you would have on your license, and the expiry date of your license. So in that fact sheet, if you click on that first link, it'll open up the register, and you can search for yourself, search for your own license, and you'll be able to see the details that are on there. Another change that we've seen under the new legislation is that license application approval times have been significantly reduced from 40 business days down to 20 business days, and that will really help people get out on the tools much quicker. There is an allowance in there for more complex license applications, but on the whole, if you've got a mate who applies for a license, then that approval timeframe will be within 20 business days. Another change that you may or may not be aware of is the technical qualifications required to hold a plumbing and drainage license were once contained in a regulation, but now from the 1st of July this year, they must now be approved by the QBCC Commissioner. Now, these have all been reviewed. There was a consultation done with STC. This document has now been approved by the Commissioner, and a list of all the technical qualifications and experience required for occupational licenses is available on the QBCC website, and that is actually the second link in that fact sheet. Another change is a bit of a language change. So what was traditionally known as compliance accessible work is now referred to as permit work. So this term permit work much better reflects the fact that a permit's actually required before the work can commence. And something else that has come in that is we can't give you these yet, unfortunately, but there's now reference in the new legislation to a set of supervision guidelines for trainees and unlicensed persons carrying out drainage work. Now, these are documents that are currently going through an approval process at a state government level. As soon as they are approved and available from the Department of Housing and Public Works, we will put them on our website, and we'll also share them via our social media. Our social media platforms are a really good way to keep up to date. So that's where we will be putting them. If you're not keen on the social media, stay tuned. We will probably put more information out about those guidelines when they are publicly available. I'm going to hand over to Grant now to talk about notifiable works.
Thanks, Regan. So I'm just mindful that we may have some of our listeners that may not be familiar with notifiable work. So I'll just quickly explain what that is. So quite simply, notifiable work is common everyday plumbing and drainage work performed by plumbers and or drainers on existing buildings without the need for a permit or any mandatory inspections by the local government. Now, when I say local government, we sort of more commonly know local governments as councils. So this type of work generally includes things like replacing a hot water heater, installing new fixtures. An example of that would be installing new toilets, showers, sinks, and also it extends to altering, extending or replacing water supply pipes. So I haven't covered all things that are notifiable work, but I will talk about this, including the categories of notifiable work very shortly. When you perform notifiable work, you must always report it to us using either a Form 4 or a Form 4A. So just for those who aren't aware of what a Form 4A is, it is effectively the same as a standard Form 4, but is used when notifiable work is carried out by or for a public sector entity or local government. So Queensland Health or Building and Asset Services are just some examples of who is a public sector entity. So when I continue to make reference to a Form 4, please take this as a reference to also being a Form 4A. So a Form 4 is that a notice is given to the QBCC that notifiable work has been performed at a property. Things that you'll see on a Form 4 include the type of work performed. This includes the categories of the work that describes it. It talks about who performed the work, and it also identifies the address where the work was undertaken. But before I delve into the categories of work, I will get Reghan just to touch on the classes of buildings, as we have received feedback from the industry that these classifications can be difficult to understand in relation to notifiable work.
Thanks, Grant. Now, classes of building are important to know because the notifiable work categories do talk about classes of building that means that you have to report that notifiable work. So essentially the buildings or all buildings are grouped by their function and use, and building classifications are labelled class 1 through to class 10. Some classifications do also have subclassifications referred to by a letter after the number, for example, a class 1A. If you are unsure about the class of a building that you're working in, please ask the owner or contact a certifier for clarification. Commercial buildings, so those are generally your 2 to 9, class 2 to 9 buildings, should have on display a certificate of classification which states the class of that building. Now, a class 1 has 2 sub-classifications. There is a 1A and a 1B. So most of us would know that a class 1A building is your typical standalone single dwelling or townhouse of a domestic nature. But it's really handy to note that a class 1B building is a boarding or guest house with a floor area less than 300 metres squared with less than 12 people living in it. So that's really good to know, especially for the categories of notifiable work. Now, along with most class 1 buildings, you may commonly find a class 10 building. Now, these are non-habitable buildings or structures such as garages or carports. Now, your class 2 to 9 buildings are of more of a commercial nature. So we're talking restaurants, shops, medical facilities, and apartment blocks. The Australian Building Codes Board has a really handy and easy to follow 2-page fact sheet, which has some clear examples of the classes. Now, in that fact sheet that we've got in the chat there, under the heading additional handy links, I've provided a link to that 2-page fact sheet. I would, if you can, print one off and keep one in your ute, just in case you ever have any queries about what class of building am I working on, and that you'll find nice and easy to follow. We do also have one on our website. If you are wanting that, go onto the QBCC website and type in classes of building. Now, Grant is going to talk more about the specific categories of work, and you'll hear more about the classes of building as he's explaining it.
Okay, so to make it easier to understand what is and what isn't notifiable work, the new plumbing and drainage regulation has reduced the number of categories from 16 down to 12. You'll see on the screen those categories of work. So it's just important to note the scope of work has not changed. So what was notifiable work prior to 1 July is still notifiable work after 1 July. The difference being that you'll now see that that most of the work is now listed under a different category number. So I'll just go through each of those, also the relevant changes. So the first thing you'll notice is that emergency work has been removed from the categories. So on a side note, you'll find that that categories of notifiable work are actually located in Schedule 1 of the Plumbing and Drainage Regulation 2019. And I would like to just take this opportunity to encourage everybody to download a copy and keep a copy of this on hand. So as I mentioned before, emergency work has been removed, and this was just because the confusion that the title created. Regardless of whether work is done as part of an emergency call out, the work completed should be notified under a different category of work that is applicable. So an example of this would be, for instance, replacing a leaking hot water heater, whereby a business wants to continue operating within the next hour. Some people viewed that as being an emergency for the purpose of their customer, but simply this could just be recorded as item 6 in the notifiable work schedule, which is replacing a water heater. So notifiable work in relation to extending, altering, replacing or removing supply pipes other than a fire service now replaces emergency work as category 1. So when I say supply pipes, it's a direct term that's used in the regulation. However, this effectively means that it's a water service. So notifiable work in relation to fire services is now category 2 and has the additional wording for an existing class 2 to 9 building. This clearly sets out the buildings where notifiable work forms must be completed. So talking about notifiable work in relation to sanitary plumbing, you'll see that this has been moved up the list and is now category 3. You'll also notice that the type of work, you'll notice this type of work is before the category for sanitary drainage. Previously that was below sanitary drainage. And it also now includes all types of buildings, whereas before it only used to apply to class 2 to 9 buildings. So when we're talking about notifiable work in relation to existing sanitary drainage, this hasn't changed and actually remains at category 4. When we're looking at notifiable work in relation to temperature control devices, we're now looking at category 5. And water heaters has now changed to category 6. Just like this opportunity to quickly just clarify that an undersink boiler unit is considered a water heater for the purposes of notifiable work. This means that a Form 4 is required to be submitted and a category 6 will now need to be selected. Also, a handy point to remember is that when replacing a hot water heater, you may need to install a temperature control device. This is, for example, a tempering valve. And with that, you'll need to select both categories 5 and 6 for work on the Form 4 that you submit. Moving on to what was categories 8 and 9, which related to backflow prevention devices, are now joined together as one, which we now see as category 7. So when we're talking about backflow prevention devices, we're talking about testable backflow prevention devices and a dual check valve with atmospheric port. Notifiable work in relation to grey water treatment plants now moves up a category, and we see that as as category 8. What was categories 11, 12, and 14, which separately relate to installing or relocating a fixture in a class 1 or 10 building. We see that now being joined together as one, and we see that as category 9. This is simply a change that combines classes 1 and 10 into the same category. In relation to notifiable work that is installing or relocating fixtures in a class 2 to 9 building of 1 or 2 stories, the words above ground have now been added. Previously, car parks were a consideration when determining the number of stories, but when we're thinking about the height, we're only considering above ground only. So for an example, we have a 3-story building, which historically may have included 2 stories above ground and 1 car car park below, which would have been excluded from notifiable work. However, this is now considered a 2-story building for the purposes of notifiable work, and we can see this now being listed as category 10. When we're looking at sealing a sanitary drain, it's now considered category 11, and it has changed slightly to now include the wording if work is for an existing building. And when we're talking about sealing a supply pipe, remembering this is downstream of a water meter, it is still the last item, but now we see this as being category 12. So just bear in mind, this only applies to existing 2 to 9 buildings. And as it was and still is, sealing a water service for an existing Class 1 building is minor work. So I'll just reiterate that. So when we're talking about sealing a water service for an existing Class 1 building, this is not notifiable work, it is actually minor work, which was the case before 1 July. Just one other thing to quickly mention is that the 4 exemptions for notifiable work is now located at the beginning of the schedule rather than at the end. This is particularly good in the sense that it will hopefully prevent mistakes being made because a person has failed to read the section right through till the end. So I'm just going to go into a little bit and talk about notifiable work, Form 4s. So a Form 4 is a notice to the QBCC that notifiable work has been performed at a property and contains information about who performed the work, what work was performed, and the address where the work was undertaken. So when a plumber or drainer completes notifiable work, they must register a Form 4 to the QBCC within 10 business days from when the work is finished. So the new regulation sets out when notifiable work is finished, and again, I encourage all of you just to look over this for yourself and not just trust me. So what I'd also like to say is that it is an offence if you do not submit your Form 4 within the required time, well, that is unless you have a reasonable excuse. Or in the case where a permit is being issued, or if you actually or if that permit actually also includes notifiable work. So the most efficient and cost-effective way to submit a Form 4 is via our online myQBCC. So this is QBCC's shop for online services, which is available from our website. In myQBCC, you can actually nominate someone on your, now that could be a staff member to actually lodge or register a Form 4 on your behalf. Alternatively, you can submit a Form 4 manually. So that's a manual registration, and we have a PDF Form 4 which is available on our website. That can be posted to you, or it can actually be processed at one of our QBCC service centres. So this PDF version has actually replaced the carbonised booklets that we previously produced. So if you still have some of those carbonised forms, you can continue to use up what you have. But after that, you'll have to start using the PDF form. So a person who is required to submit Form 4 must do so, and part of that includes having to issue an explanatory statement to the owner of the premises where the work was carried out, or otherwise the person who asked for the work to be carried out. So this must be done within 20 business days of the notifiable work having been finished. So I just can't stress enough how important it is that this be done, because if it's found that you have not, you may be looking at a fine, as it is an offence not to do so. Even worse, you may be looking at at prosecution. So just to briefly explain what an explanatory statement is, this is a document that states that the notice, the Form 4, was given to the QBCC Commissioner, how a person may inspect the notice, and that the local government may contact the occupier to arrange an inspection for the local government to inspect the work.
Okay, we're just going to look at some of your questions regarding notifiable work. Before I do that, one of the key questions that came up in our previous webinar, and something that our contact centre does get asked about a lot, is what is the differences with the notifiable work categories. We actually have, and I've provided a link in under the heading notifiable work in your little handout there, and it's actually a comparison table. So it's got what the previous categories were to what the new categories are. So you can also print that out, keep that in your and that might make things a little bit easier for you. And off the back of that, there was also commonly asked question about this explanatory statement or letter, as Grant just mentioned. By fully completing the owner-occupier section on either the PDF form, Form 4, or even if you lodge it online, you will be meeting the explanatory note requirement. So you don't need to provide anything in addition to the Form 4 notice. It actually prompts you to fill out under the owner-occupier section on the PDF form. It'll prompt you to put the date that you lodged that with the Commission, and in bold underneath that, it has everything else in there. So make sure you fill out that Form 4 completely all the way through to the end, and then you've nailed it and you're good. One of the questions that we do have is, do we have to submit a Form 4 if we remove and install plumbing fixtures into existing places? So I'll pass over to Grant to answer that.
Thanks, Reghan. So in this case, removing and installing a fixture is effectively like for like, and is the same as replacing a fixture. So this type of work is considered to be minor work, and Schedule 2 of the Plumbing and Drainage Regulation will actually list the type of work that we see as minor work. So again, just if you're replacing a fixture like for like, in the same position, then this is considered to be minor work, and this means that a permit is not required for the work, or that the person is required to submit a Form 4. So simply the work can be done without any mandatory inspections or permits or Form 4s.
We've just got another one here. Does notifiable work waive the need for local authority plumbing and drainage approval, or do you still need local authority plumbing and drainage approvals?
So in this case, it's either notifiable work or permit work. So you need to determine the type of plumbing and or drainage work, and follow the appropriate process. If work is notifiable work, you do not also need a permit for the work.
Now, just around the cost for lodging a Form 4, Grant mentioned earlier about myQBCC. For those of you who are wanting a link to that, it's actually the second bullet point under the heading notifiable work in your handout. That'll take you directly to the myQBCC page. It's cheaper and easier to actually lodge it electronically. So it's $31.45 to lodge it online, as opposed to filling out either your old carbonized booklet or the PDF form and handing it in manually or posting it in. If you do that, it is $42.45. We've got one more question here. If you're performing permit work, can we notify under a Form 4 where we get a minor variation to add a fixture to avoid the need for going through the ringer on seeking new approval from local government for the permit work?
That was a bit of a mouthful. So the direct answer to that question is no. So where a permit is issued by the local government, any variations are required to be assessed by the local government. So the local government may require an application be made to amend the permit. However, the local government may also decide that an amended permit is not required. So I suggest that you contact your relevant local government for more information if necessary.
Okay, so I think we'll carry on and answer some of these other questions at the end, but that was sort of the main theme of notifiable work questions. Grant's going to talk about the approved audit programs. Someone mentioned about the classes of building links. So that document that I said before, that was from the Australian Building Codes Board, that's under the heading additional handy links in your handout. So Grant's going to go on now and talk about the approved audit program.
So the QBCC regularly conducts audits, and that's to ensure that plumbers and drainers are lodging Form 4s when they have carried out notifiable work or when they've finished notifiable work. So this legislation supports this. When I say this legislation, the Plumbing and Drainage Act supports this by giving the Commissioner authority to prepare and approve an audit program under which we can audit licensees to find out whether they have been complying with the requirements after finishing notifiable work. So what this means is that we may conduct audits to see whether or not you are registering your Form 4s on time and every time. So the QBCC website, so on our website, we actually have notifiable work compliance sections, which outlines the purpose, it outlines the duration, and also criteria for the audits. So on the screen, you'll actually see an example of what an approved audit program may look like. So in this case, you'll actually see that we have a purpose, we have a duration, we have the criteria for licensees. You'll also see the classes of license which are subject to the audit program. How will licensees be advised that they've been selected as part of the audit, and the obligations of those licensees if they have been selected for an audit. There are there are different forms of enforcement action that the QBCC can take if you do fail to take the necessary steps after finishing notifiable work. And this is assessed on a case-by-case basis. For example, if you do not give a Form 4 with the explanatory statement to the occupier or the owner, the QBCC may look at issuing you a fine, which is about $800 currently. Also, future offending of the same nature may put you at risk of tougher penalties. This may include prosecution, where the maximum penalty could be about $8,000. So the QBCC may also take or consider taking disciplinary action against you, including suspending your license. Something else that could happen is placing a condition on your license, or the QBCC could have or could make you pay an amount of up to $13,000 thereabouts. So once a Form 4 is registered, a local plumbing inspector may inspect the work to ensure it complies with all the codes and standards. The building owner or the plumber can actually request an inspection at any time during the work. These inspections are carried out by the local government authority themselves. So I'll just move into the penalties. So a range of new offences have been introduced, along with increases to some of the existing ones. If you're responsible for directly supervising a trainee who is carrying out plumbing or drainage work, or directly supervising an unlicensed person, this is in relation to carrying out drainage work, you must also provide appropriate direction to the trainee or unlicensed person on how to carry out that work. Also, you must ensure that the work complies with the Plumbing and Drainage Act. There are a number of actions that you're required to take to make sure that you also keep on the right side of the law. It's really important to just remember that you must advise the QBCC of any changes in your circumstances, such as your name, your email address, phone number, or your residential address. If you hold an interstate or New Zealand license and you have a condition imposed on that license, you must advise us. You must also advise us if that license is suspended or cancelled. This information must be provided to the QBCC within 20 business days, and if it's an offence if you do not. I've added a link in our chat to the Form 26, which is the Notice of Change in Circumstances. You are also required to return your licence to us if you're advised to do so. And this must be done within 10 business days after our request, unless you have a reasonable excuse. So, like I said, it is an offence not to comply with this request, but please don't dispose of your licence and talk to your team, talk to our team if you're unsure. For some time, the industry has been vocal about defective work carried out by unlicensed persons or persons without sufficient supervision, and also the lack of sufficient deterrence to prevent this from occurring. So, to address these issues, the previous maximum penalty regime has been replaced with an escalating maximum penalties schedule. What this means is the maximum amount someone can be fined goes up with each subsequent offence, or in cases of grossly defective work, a maximum fine of up to $46,000 or 1 year's imprisonment could be imposed. These changes give the QBCC the power to really crack down on repeat offenders. So I'll just move on to false advertising and misrepresentation, and we talk about watermark products. So it is now an offence to provide false advertising or misleading representations of particular things. This is the first time there is a reference to the word thing in our legislation. So what is a thing? Generally, things are referenced, particularly things are referenced in the Plumbing and Drainage Act, and includes, for example, a product to be installed in plumbing or drainage. Things must not be installed unless they have a watermark product that complies with the code requirements and are not a prohibited watermark product. However, there are things other than watermark products that may still be installed in plumbing and drainage if that thing is prescribed by regulation. At this stage, the regulation approves certain fire service products as a thing and approved for installation as plumbing and drainage. However, there are other requirements that must be satisfied, which are also listed in the regulation. The use of the word thing allows for specific items and certifications to be called out and future introduction of new products via regulation. This means that our industry can continue to encourage product innovation. So I'll just go and briefly talk about safety incident reporting. So we go to work every day and our loved ones expect us to return home safely. In one piece, this ensures that our workplace is a safe place to be. Protecting your mates and members of the public is of paramount importance. If you become aware that a notifiable incident has occurred on a building site, which is under the licensee's control, or where the licensee is carrying out building work, the person must give the QBCC notice of the safety matter. So a notifiable work incident is the death or serious injury or illness of a person, or an accident that exposes a person to a risk of serious injury or illness. The quickest and easiest way to notify us is by using our online notification form. If the matter is urgent, please call us on 139 333. So to date, there has been 126 notifiable incidents reported to the QBCC. We've taken action on 37, proposing that a condition be placed on a licence, which would involve obtaining an independent safety audit report. So of those 37, QBCC has only imposed this condition on 15 licensees.
Okay, so we're going to have a look at some more of your questions. Now, I've just had a couple of people ask about where that fact sheet is. It's under the heading handout on the right-hand side of your screen. There's a little, instrument panel that you can see, and it's under the heading handout. Now, also, Grant mentioned the approved audit information and showed a example on the screen, there is a link to the page on our website in that handout under approved audit information, and you'll see in there the current audit program that has been approved, who those licensees are, and the process that it goes through. So we also have a question here. Does a Form 4 need to be completed where there is a plumbing approval in place?
So again, the direct answer to that question is no. So a Form 4 is not required to be submitted to the QBCC where the work is part of a permit. You may make an application to the local government for a permit that involves notifiable work.
We've just got another question here, a very good one, thank you. Why are Bunnings allowed to sell non-watermarked products and sell installation services while being completed by unlicensed plumbers who are not completing Form 4s? I think that's actually a couple of questions or a couple of different answers there, Grant.
Okay, thanks, Regan. So I'll just sort of read that question again so I get an understanding of that. So why are Bunnings allowed to sell non-watermark products and sell installation services which are being completed? So in terms of the likes of a merchant selling non-watermark products, in this case, it is difficult because you can use certain products that aren't typically installed in a plumbing and drainage system. So I guess the question, the answer to that question is that it is permitted for the likes of some merchants to sell certain products. It's just that if they are being, or if they're sort of identified as being able to be installed in a plumbing drainage system, then that's obviously when they're required to be watermarked.
And just, I guess, a bit further to that, the second part of the question was being completed by unlicensed plumbers. Grant mentioned before about tougher penalties and mentioned escalating penalties for unlicensed plumbing work. So in the legislation, we do have the powers to go after unlicensed persons. We have to, I guess we can't be in all the places at all the time. We do rely on information coming back through to us. So a great way to get us the information, there's a couple of different ways. Because you need to have proof, right? You need to have a quote or something, an invoice, a contract, or something that proves that that particular person undertook that work. So if you hear a homeowner say to you, oh yeah, this person did the work, and you look up and find out they're not licensed to undertake that work, then I would be encouraging that homeowner to lodge a notification of offence, which I haven't linked in our fact sheet, sorry, but it is on our website. So a homeowner can send us that complaint. We can investigate it. And there are some very serious penalties now for people who do undertake unlicensed work. We do have escalating penalties for that. There are fines in the first instance, and it can actually escalate up after the number of times, if they're repeat offenders, up to possible 1 year's imprisonment. So we do take it very seriously. Now, we do have another question around, is there a requirement for 3 Form 4s on a job if you've done drainage, final fit out, rough-in, if these are 10 days apart?
So a Form 4 is actually required when notifiable work is finished. So this is when a payment is to be made for the work, or otherwise when the work becomes operational. So if payment is to be made for all or any part of the work, and any work for which that payment is to be made, it's actually taken to be finished by definition in the Act. And a Form 4 actually must be submitted at that point in time. So this means that you may be required to lodge a Form 4 at each stage of the work, if an invoice is actually given at each stage of the work.
So I guess leading on from that one is along the same lines, this question. If there's one contract, but 4 progress invoices and 1 final invoice, how many Form 4s are required?
So just as I mentioned before, notifiable work is actually deemed to be finished when payment is to be made for all or part of the work. What this means is that you actually that if you give a person an invoice for part of the work, then you must submit a form for it. And that's irrespective of whether additional work is yet to be completed.
Okay, so I'm just going to step away from Form 4s. We don't have any more questions about that, but there is around the notifiable safety incident, not notifiable work. Very similar words though. In that handout, down the very bottom of the handout is notifiable safety incident as the heading. I've put in there a link to the online submission form. We do understand that this lodging these types of incident reports may be new for some of you. It doesn't negate your requirements under the workplace health and safety. You still must report to them as well. However, you also must advise the QBCC. Now, a notifiable safety incident is a serious injury or illness where immediate treatment as an inpatient in the hospital or immediate treatment for the amputation of a body part, serious head injury, a serious eye injury, burns, a serious burns, when there is any sort of loss of bodily function. So pretty much if you have someone on your job site who has to go to hospital and seek treatment or seek medical treatment within 48 hours of exposure to a substance, or if there is a death on site, then you must report those to the Commission. And you can do that via that link in the handout or give us a call. If you're unsure and you're not sure what you have to report to us or where the form is, please ring us 139 333 and we'll be able to point you in the right direction, or go to our website and type in safety incident, notifiable incident, language along those lines, and that will pull up that form for you. Now, I've just had one other question. If you have 4 PO purchase orders, right, given to the plumber, who then invoices 4 times, that is 4 forms. It's kind of more of a statement, but I'll hand over to Grant.
So when you're talking about purchase orders, I'd sort of go and think about when you're actually issuing an invoice for the work. So what the Act says is that if you are performing notifiable work and you are issuing an invoice for all or part of that work, then you must submit a Form 4 when you issue an invoice for the work, or otherwise when the work becomes operational. But in the first instance, if you're issuing an invoice for the work, then you must submit a Form 4 within 10 business days after you have issued an invoice for that work. So I hope that answers that question.
And look, when we're talking legislation, you're more than welcome to, and I haven't provided these links in that handout, sorry, but on our website, if you scroll to the very bottom of any page that you are on, there is little blue headings. One of them says legislation. If you click on that, it'll actually pull up a page that has links to all of the legislation. You'll see the most recent Plumbing and Drainage Act and the regulation in there. When we're talking, like when Grant's talking now about the definitions and what it says in the regulation and in the Act, Section 82 of the Act, it's very clear in there about the wording invoices and the definition of when notifiable work is finished. So if you want to read it for yourself, Section 82 of the Plumbing and Drainage Act. We've got another one here. What happens if you do not get paid for the job or the job does not get finished? Do you need to lodge a Form 4? Good question.
To answer this question, what happens if you don't get paid for the job? I do understand that in some cases people do not get paid for the job, but unfortunately what the Act says is that if you issue an invoice for the work, regardless of whether you get paid or not, that is the trigger for lodging a Form 4. Now, if the job is not finished, if you issue an invoice for the work, then that's the trigger to lodge a Form 4, or otherwise when the work becomes operational. So if you've got a job where it involves two aspects of notifiable work, for example, if you've got a bathroom renovation as well as a kitchen renovation, and you go and complete that bathroom renovation, you may not issue an invoice for the work, but that work becomes operational. You are required to lodge a Form 4 when the work becomes operational. And so that means you may have to issue a separate Form 4 once you've completed the kitchen.
We've got another question here. Does upgrading an existing amenities block in a high-rise building, changing like for like, not adding fixtures, that doesn't need in-ground drainage, require a Form 4, or does it need to be done with hydraulics?
So when we're talking about changing like for like and not adding additional fixtures, irrespective of whether it's in a Class 1 building or a Class 2 to 9 building, it may be a Class 2 to 9 building that exceeds 1 or 2 stories in height. I guess the fact of the matter is that the work that you're doing is replacing a fixture, which if you look at Schedule 2 in the regulation, it describes in there that replacing a fixture is actually minor work. So therefore, a Form 4 is not required.
As a builder, do I need to monitor whether my plumbers lodge a Form 4?
So in that case, it is the plumber that is actually carrying out the work. So it talks about licensees needing to lodge the Form 4 when required. So as a builder, I would encourage all builders to, in the case that a builder engages a subtrade or a subcontractor, including a plumbing contractor, that's the person that has asked for that work to be carried out. So therefore, that plumber effectively should give the builder a copy of the Form 4. That way, you can monitor whether a Form 4 has or hasn't been submitted.
And just following on from what you were saying before, Grant, there's we're sort of going back again, and this is around the Form 4s, and you were talking about it not like the invoicing being the prompt. So this question is, but it's not operational until after fit off. You can't expect clients to pay for 3 Form 4s for renovation work for each stage.
So I guess where we have to apply the Plumbing and Drainage Act, and what the Plumbing and Drainage Act says in relation to notifiable work and when the work is finished is that if it says that notifiable work is actually finished when you issue an invoice for the work, and you're seeking payment for that work. What it also talks about is that you may issue an invoice for all or part of that work. So it's quite specific in the Act that says that if you would issue an invoice for part of the work, then you must submit a Form 4 at that point. So I guess that the answer to that question is yes, you do have to lodge a Form 4 along each stage of the work if that's how you choose to operate your business.
And I guess following on from that is another question. Why don't you have the first Form 4 on a job paid for, and then subsequent Form 4s are at no charge until completion. Before I hand over to Grant, I will say that the QBCC doesn't write this legislation. This legislation is written by the state government, and it is then given to the QBCC to enforce. So we have to adhere to the words that are given to us in the legislation. So because it's not allowed for in the legislation, we can't sort of deviate from that. But I'll hand over to Grant for further explanation.
So I acknowledge the question and the fact that there will be subsequent work or parts of work that are undertaken that includes stages. But like Reghan said, unfortunately, the Act is quite specific in what it says in terms of when notifiable work is finished and when you must lodge a Form 4. And I said it's a policy a decision, and unfortunately we have to follow those directives.
And this is now the time where we wrap up. We've had some fantastic questions. What I'm going to do is, because a lot of these questions really picked up on the themes of the questions we got asked in our previous webinar, if you're all okay with this, I would like to compile all of these questions that you've asked, put them together with the questions that were asked in our previous webinar, and I'll distribute them all out to you as participants. Hopefully, maybe tomorrow, what are we, Friday? I'll send that out to you via the email that you've registered. I just wanted to point out one more time, for those of you who were looking for where this wording is, it is the Plumbing and Drainage Act 2018. There's a link on our website, and you are looking for Section 82, when notifiable work is finished. I hope that that's helpful. I hope you found this informative. We've just had one other question come through. Why can you not just amend the original Form 4 as the work progresses?
There's no opportunity. Sorry. Yeah, so the Act doesn't allow that to occur, and quite simply, when a Form 4 is submitted, there is no opportunity to amend that Form 4. So I guess that's the answer to that question.
Very good. Thank you. Thank you all very much for your wonderful questions. It's been really good. As I said at the beginning, we will make a copy of this webinar recording available on our website after the 1st of August. We do have one more webinar next week, so if you want to listen to our dulcet tones again, you're more than welcome to register for next week's session. If not, I hope you have a wonderful evening. If you have any questions, please, the email that I send out to you tomorrow will come from one specific email address. You're more than welcome to reply and ask further questions there. Have a wonderful evening. Thank you for coming.